Well, welcome back to the Law&Crime Network. My name is Bob Bianchi, and I'll be taking you from 12 to 3. We've got a lot of activity going on here today. We're going to be recapping some of the additional, most memorable trials, doing a Law&Crime rewind, if you will, with regard to a number of cases that I have two great guests that are going to be able to help us out here today with regard to that. Some of the upcoming trials, the memorable trials that we have, as you see on our screen right there, at 12 is going to be Tex McIver. At 2 p.m. will be Daniel Villegas. Then 3 o'clock, we're going to have Quentin Tellis. So that's what we got coming. And I've got Linda Kenny Bodden and my hashtag 4041, Gene Rossi, are going to work us through with that. Okay, we're doing the Law&Crime rewind, all right? And one of the fascinating cases, I love this case, was the Tex McIver case. And the reason I love it is that it has so many moving pieces to it, so many permutations and evidence issues. It was a hotly contested case in the courtroom. The lawyers on both sides really knew what they were doing. So Tex McIver was a prominent lawyer in Georgia. He was accused while in a car ride where their friend was driving and his wife was in the front passenger seat. There you see him right there. Tex McIver was in the back seat, and he indicated or claimed that he got a gun from the console of the vehicle from the passengers in the front because he was scared of the area that they were driving in, and the gun accidentally discharged, went through the front passenger seat and shooting a single shot that shot and killed his wife. The prosecution saw it differently. They brought out a lot of financial evidence in this case to indicate that their motive here was to actually commit a homicide, and this had nothing to do with it being an accident. So there were two completely different narratives, and at the end of the day, the result was just as amazing when the jury came back with its decision. But first, let's go to the prosecution's opening statement here to get a little flavor of what this case was all about.
In addition to putting the gun in a plastic bag, 8 hours before the murder, the defendant asked Tanner McKinney to take Danny Joe Carter back to Atlanta. Now, Tanner McKinney and Samantha Watson are two young adults that come out to the ranch on a couple of Sundays out of the month in order to groom the horses and to walk them or to ride them. Tanner will testify that he lives in Athens. The gun that was used, the .38 revolver, was in perfect working condition. It was tested by the GBI and Michael Knox. They fired it, and they did other testing on it to determine that it had no hair trigger. In double action, it required 12 pounds of trigger pull for it to fire. And in single action, it was 2.5 pounds.
Georgia versus Tex McIver. There you hear the prosecution's opening statement. This was no accident. This was a purposeful pointing the gun through the seat, shots fired to kill his wife. It was done intentionally. It's a premeditated, intentional murder. I got two great guests with me. Happy New Year to my Jersey girl, Linda Kenny Bodden. Happy New Year. Trial lawyer extraordinaire, former prosecutor, defense attorney, does all things great. It's great to have you back in 2019, Linda. And the Gene Rossi, hashtag 4041, 30 years at the DOJ, trained over 1,000 prosecutors, now doing criminal defense work. And Gene, I understand that you have a new Gene Rossi radio show. How do we get to that?
It's a long story. I ran for Lieutenant Governor of Virginia and made a lot of contacts. And John Fredericks owns a radio show in Richmond. So I will be on Saturdays at noon. And you can watch it live on WJFNradio.com. I'm very excited.
Is this a call-in show, Gene?
It's a call-in show, so please call.
Dude, I am going to be harassing. I'm going to get my Jersey boys and girls to be harassing the heck out of you on your show. But hey, happy New Year, Gene, and congratulations. No better guy than you to have his own show.
Happy New Year.
Yeah, Happy New Year. Guys, listen, the opening statement here, the prosecution laying this part of the case out, that he actually pointed the weapon. Now, I want to talk about one thing that the prosecutor said in that opening statement, and Linda, I'm going to go to you first, where they did a recreation, and they had an expert. The audience should know that at a certain point in time, the judge allowed the jurors to actually go to the vehicle, put the gun in their hands and actually, I guess, themselves recreate. We find out later from the jurors that this was very relevant, this thing, but we at the time were surprised because some states won't allow that kind of recreation because you can't really capture what's happening there. What are your thoughts?
Right, absolutely. Remember in Scott Peterson, who's on death row right now for the murder of his wife and unborn child, the jurors got into a boat and rocked it to their own recreation, and there was an issue, there was a problem with that, even though it didn't overturn the verdict. In New Jersey, we couldn't do that because they're becoming their own expert. They're saying, okay, well, let's see, if the, they're not in the car with the bumps, they're not in the car with the speed, they're not in the car with somebody who's kind of, nodding off. So it really doesn't have all the circumstances. So it can be an issue on appeal.
Yeah, I mean, they're basically recreating something that we don't even know if they're recreating it accurately. Gene, let me add to that one of the jurors is quoted as saying, essentially, that this was very convincing to them and that there were gun experts on the jury that started giving their expert opinion about weapons that was not necessarily what was testified to inside of that courtroom. Do you see these two things as a potential appellate issue?
No, because the experience of a juror is something you can carry into that jury room. As long as it's not unfairly prejudicial, they can base themselves or base their opinions on experience that they have. If you had a trial in Mississippi, a lot of people hunt. You're never going to get a jury that doesn't know about guns, so I don't see a problem with that.
All right. Well, Gene and Linda,
disagree.
There's a disagreement on that. That's fair enough. It certainly will be an issue on appeal. The question is whether it will be successful. But listen, that was the prosecution's opening statement. The case didn't end there. The defense had a very strong, credible defense that they presented in this case as well. Let's take a look at their opening.
Accidental. So we looked at the gun already. So here is what's shown in these pictures is the passenger seat of the Expedition. This picture in the bottom left corner with the number 2 on it, that's the back of the seat. You can see that that's where the bullet entered the seat. This picture over here on the right, and I hope you all can see it, shows you that there's a lot of kind of mechanical workings on the inside of the seat. I think those relate to maybe the seat heater or maybe the motorized seat. I don't know. But the point is that this bullet passed through all of that before it came out of the front of the seat, which is that top left corner where the number 3 is. The evidence is going to show you that it is not a guarantee or even likely that you would be able to kill somebody in this method. And that's why the shooting was accidental and not intentional.
Gene Rossi, there you have the defense opening on the Tex McIver case, saying the complete, essentially opposite of the prosecution, if you will, in terms of trial dynamics. This was an unfortunate and tragic accident. Now, as will be developed during the course of the trial, as well as what occurred during the openings, was that they were driving, and this woman is driving the vehicle. The wife is in the front seat. They decided to go off an off-ramp because of traffic, and they were concerned where they were. Tex asked, can you give me the gun, because they were concerned. It's a single round that's fired, not multiple rounds. And the defense throughout all of it was saying this would be the oddest way to try to kill somebody, and this gun could have went off accidentally, and you don't have to accept what those experts for the state say because nobody ultimately can tell you exactly how this was done. What were your thoughts of their opening?
Well, I thought the prosecutor's opening was a little better, and here's why. If she's correct that they will prove that a bullet went straight through her back, and it wasn't at an angle, it wasn't at a position that would be accidental. If they can show that that happened, then he will be found guilty, and obviously he was. But I thought the prosecutor gave a little bit better opening. They both gave good openings. I thought the prosecutor was better.
Now, you gave the tease away a little bit there, Gene Rossi, in that he was found guilty, but he was found guilty not of malice murder, Linda Kenny Bodden. He was found guilty of felony murder. In other words, the jury was essentially saying, we don't think that he planned or plotted or premeditated it. The felony, the underlying felony, the predicate offense, as we would say, is aggravated assault.
Right.
And during the commission of that felony. So it was really a weird and inconsistent kind of verdict.
It was weird because I was surprised at the murder until I found that felony murder to have, and that's a problem. Felony murder across the United States is being debated because to me this was a manslaughter. Obviously he's taking out a loaded gun, right, in the middle of the day. He's kind of got a sleep issue. The car is moving and it shoots. Now you have to be perfectly, actually he was lucky because if you look at the seats and he took away the seats, they have all this stuff in them, metal and all. So he had to shoot exactly where there was no metal. So I was amazed that this was a murder, and I think the felony murder also becomes an issue then on the appeal.
Right. You know, Gene, what Linda is bringing up is there is a big debate in the community, in the legal community, about this felony murder rule. But what it was intended to do, for example, was the traditional, you go in an armed robbery, and, you know, during the course of that robbery, somebody is killed, even if you did not intend that they be killed. The fact is you committed a predicate offense, robbery, where somebody died. We get that. But a lot of people believe that this felony murder rule is kind of being twisted. And listen, I'll be honest with you, as a homicide prosecutor myself, felony murder was my best friend.
Oh, felony murder is fantastic. It's sort of your ace in the hole because, and I got to agree with Linda. We disagreed mildly. I got to agree with Linda that on appeal this could be trouble because if they didn't find him guilty on count one, which was malice murder, they call it, it's very difficult to find him guilty on the remaining counts. They did have 2 lesser included on involuntary manslaughter.
Yeah,
And, they didn't have to get to that.
You know, Gene, I agree this is going to be a big issue on appeal, especially because the jurors were, had to basically be brought back in and told under the Allen charge that you need to try to come to consensus. The jurors are saying that they were all over the place. It seems like a compromised verdict. It sounds somewhat inconsistent. I'm just saying that that's the great weight of legal authority that looked at this verdict believes, those that are out there that do this for a living, that there are problems with respect to how this verdict came out. So it'd definitely be something on appeal. Hey guys, we got to go to break, but we'll be back with some great more analysis from Gene and Linda in a moment.
And I'm going to ask you, if you would please, to come over and would you recognize this to be a demonstrative aid, right? Mm-hmm. And yes?
Yes.
Okay. And can you share for the jurors the demonstrative aid that we see in the courtroom? Is it similar in any way to the actual vehicle that you were driving that night?
Very similar.
And can you tell the jurors how so? All the different ways if you can.
Bucket seats. The seats were behind it. The color's almost the same. It looks like that says King Ranch, which is the style car that it does. So it's very similar to the vehicle that we were in.
Okay, how about the console itself?
Yes.
All right. So I'm going to ask you if you would please occupy this demonstrative aid where you would have been that night.
Okay, so that's the prosecutor asking questions in a Tex McIver case of Danny Joe Carter, who is the driver of the vehicle. Linda, just one thing I want to point out that the prosecutor was bringing up. There were no crowds. No one was approaching the car. They got on this off-ramp. They went off the highway. According to Danny Joe Carter, Tex, the defendant, says, "Girls, wish you wouldn't have done this. It's a bad area. You should have stayed on the highway." And then ultimately we find out that he's going to ask that the gun be passed back. It just seems like such a, unless Danny Joe Carter, at least this is how I felt during the trial, was actually involved in a conspiracy to murder her, Tex McIver's wife, it was just such a fortuitous, if you will, a random set of facts. Did he just make up his mind in that second? Oh my God, what a great opportunity. Let me get the gun. Now I've got my motive. Now I can fire one round through all that metal in the car, as you've indicated, and I can get off scot-free and get all our money.
Well, that's what I felt at the time of the trial. Well, they were going on the highway, and obviously he wasn't going to take out the gun on the highway. And let's face it, Bob, we know people can be racist. They see one black person, all of a sudden, it's a terrible area, right? So maybe that's the way he felt. Maybe he thought this was a good opportunity. Maybe he had planned it. Maybe that's how the jury felt, and that he was just waiting for the time.
Yeah, but Gene, to Linda's point, I mean, obviously that's the argument that the prosecution made. You would be committing this act in the presence of another person. You would have to wait for the right circumstances to occur. You would have the gun in the front of the vehicle as opposed to being on you, should that have been what your plan was. It just, from the standpoint of just common sense to me as it was coming out, didn't make sense, at least to me.
Well, I like to embrace the negatives. Everything you said is accurate. You got to understand, this guy's 75 years old. He's a very skilled attorney. So he is thinking, if I get caught killing my wife, I got to have a good excuse. So I don't know if he picked that exact ramp, but he probably thought in his mind, and the jury probably agreed, that at some point during that ride, he was going to find an opportunity to pull the trigger. This is the government's theory. So I will say this, though. He had the comment, girls, you should have stayed on Route 85. That sort of points towards innocence. But if you're a conniver, like MacGyver, this is perfect for you if you're going to kill your wife.
Yeah, boy, that's why you got that radio show, Conniver like MacGyver. You got to love it. Gene Rossi, you're bringing it home, hashtag 4041. All right, listen, we're going to go to a short break, and we're going to come back with more of the Law and Crime Rewind. And don't forget, we got all these other fascinating trials that are getting ready to get started. We are all over it. We'll be back after the break.
I'm gonna approach you.
Yeah.
Let me know when to stop.
Yeah.
No, we're not real close. Are we this close?
I'm about this close.
Okay. And how long do you think we can have a conversation with them like this?
Maybe 10, 20 seconds. 10 seconds.
Why are you? I know you say you're in consoling mode. Why are you that close to there? Are there reasons for that?
I wanted him to feel like I was concerned about him, concerned about his wife, involved in the matter, and also, you have to be quiet. You have to quietly talk to someone. There's HIPAA violations. If someone were to overhear medical information, that would be wrong.
And when you're this close to him, is there anything that you remember about his appearance or anything that sticks out in your mind as you're having this conversation with him?
Sure. So he was red-faced, and I didn't know if that was a sunburn or just his complexion or what. And I did smell alcohol.
Case, one of our classics for 2018. We're doing the rewind here. That was Blair Brown. She's an ER nurse. She's trying to find out what happened to Diane, the wife. They can't find the bullet wound, so she goes out to give some personal items of Diane to Tex McIver, who's on trial, and she starts to ask questions. She asks what happened, and he says it was an accident. It just went off. He had delayed responses. He was perplexed. She was perplexed that, oh my God, the patient was shot by her husband, and the prosecutor then asked, did he ever say that the car hit a bump or that there were homeless people or Black Lives Matter people? And she did not recall any of that. That became the centerpiece of the defense as the reason as to why he was concerned about having that weapon. Linda, how did she do for the prosecution?
He wasn't asked, though. He wasn't asked about that. He was asked, what kind of gun did you use? That's what she was looking for. So, but yet the prosecution uses it like they would in any police statement. Well, you didn't say this. So.
Right. Yeah, Gene, do you agree with that? I mean, this may not have been the form in which he would have been given chapter and verse.
I disagree with Linda.
Oh, no, 2 times in 2019.
How do you like this? I thought she was phenomenal. And if I ever have to go to the hospital, I want her, okay? Number one, a couple of things came out that really struck me. He paused. What kind of gun? He paused. Are you kidding me? And is he pausing because he doesn't want to tell her because it'll help them save the wife? That's number one. Number two, I think what they're setting up is...
Real quick, Gene.
Yeah, he didn't mention the bump, the homeless, and Black Lives. I'm wondering if he did mention that to the police later, the inconsistency.
Yeah, those are excellent points. That's why I love having you guys on. We are doing the 2018 Rewind. We got to go to a break. We'll be back on the other end. Stay tuned. Well, thanks, Anthony. You know, I always say, Linda and Gene, that when you're discussing your conspiracy theories in a hot tub, you always got to make sure you're protecting your ears. You got to. It's just an absolute given, because anybody could just bite them right off when you're talking about conspiracy theories.
We have a wonderful executive producer of this show, Kathy Rossi, who's in Utah, and I'm making the connection because I want to know between Mitt Romney and that, what's going on in Utah?
No, man, you can't make this stuff up, because if it wasn't for guys like this guy, the ear-biting guy, people like us wouldn't have jobs.
That's right, we'd be out of business.
Okay, listen, guys, we're doing the Tex McIver case, so we've gone through the prosecution's part of their case with regard to the driver of the vehicle, the ER nurse. But, one thing that they're going to have to try to tie together here, now we all know this, you don't have to prove motive in a case. That is not an element of an offense on a murder charge, or for any charge for that matter for the prosecution. But of course, prosecutors want motive, especially when there's such a wide difference in opinions as to what happened in the case. Prosecution saying that this was a planned murder, as opposed to the defense that is saying that this was an accident. So motive played a crucial role, and the prosecutor hammered and hammered and hammered the financial situation that Tex McIver was under with regard to his wife Diane McIver, basically saying that he was failing, she was loaning him money, she had the thumb on the scale with regard to him, and that was the motive as to why this is a murder. So let's listen to the prosecution's opening and how they actually framed that motive for the jury, I think rather successfully.
And over the 3-year period from 2013 to 2016, our financial expert, Mr. Dean Driscoll, will testify that he received $198,000 from Diane McIver. In addition to the $198,000 that he received from her, she gave him a loan for $350,000 in 2011. This wasn't a, hey, you can pay me back whenever you get the money. This was an actual loan with a promissory note. And the loan was secured by the ranch out in Putnam County. And based on his financial condition, the defendant would not be able to repay this loan. In fact, the evidence will show that in 2011, when she gave him the loan, it was due in 2014, and he hadn't paid it. So she renewed it, so they would be due in December of 2017. And the evidence will show that over that period, he made interest-only payments and never paid any money on the principal. And in addition to that, without the money from Diane that he was receiving every month, on the time of her death, the defendant wouldn't even have $1.
Welcome back. We're in Tex McIver. That's the prosecution's opening statement. As I indicated before, not having to prove motive, but trying to really nail down, and they hammered this throughout the trial, this motive. Linda, there's loans that are outstanding here. There's this issue about this ranch that she wanted to give allegedly to her godson, Austin. There's all sorts of evidence that they brought out during the course of this case that the financial scenario that he was under was dire, and that was the motive for him to do this act. Do you think the prosecution was effective in that presentation of evidence?
Well, it's certainly effective if there's no defense response to it. But, I mean, if I'm doing the defense, I want to bring in a bunch of tax accountants to say, look, of course you do that because she's going to give him money anyhow to do what he wants. But this way it gets written off as a bad debt, right? In the way the tax laws were there. And I want to mention something. Husband, who's probably hopefully watching this or will see it sometime. All those shoes you buy me, maybe we should do a promissory note. I should then never repay you for it and get a tax write-off of some sort. I mean, come on.
I'm taking the fifth on. Gene Rossi, I'm not even touching that. Hey, Gene, to Linda's point, though, in marriages, there's complex financial arrangements, especially with people that have a lot of money like these folks do here. And certainly in most cases, I'd be arguing as a defense, in virtually every case, doesn't result ultimately in murder. And that they're trying to put a square peg in a round hole. Listen, I think the prosecution, me and you do a lot of critiquing of lawyers, I think the prosecution is really strong. She has a really good cadence in that courtroom. It's certainly evidence she wants to bring out. She did bring out, successfully brought out. What are your thoughts?
I think her style is very appealing. She doesn't look at notes. She looks at the screen, but that's understandable. She's connecting with the jury. You can just feel it. I want to go to motive, though. As we know, it's not an element. But this is a weird marriage. The $350,000 fully secured loan tells me one thing. The victim did not trust her husband. And number two, $198,000 for over 3 years. Wow, this guy is just milking at the trough here. He's got quite a life, and it is motive. It is motive.
You know,
doesn't prove it, but it's motive.
Actually, Gene, it's interesting you should bring that out because there were arguments made during the course of the trial that by him killing her, he actually ended the gravy train, if it were, that the cash cow was now depleted. I mean, that was an argument that was made, and they went back and forth with this, but an excellent point that you're making. Of course, as we know, that a lot of this is speculative, but prosecutors often want to get expert witnesses that are going to testify because an expert can talk more than just facts. They can give their opinions and their conclusions based upon that expertise. That's exactly what the prosecution did with Dean Driscoll, who's a financial expert. Let's take a look.
Another category down here at the bottom.
I do. Those are transfers directly from his wife to his accounts, and that those were across all of 6 accounts.
Okay. And these are cash transfers into Mr. McIver's account from his wife.
Correct.
So in 2013, can you tell the jury what is the total amount of cash transfer from Mrs. McIver into Mr. McIver's account?
A little over $180,000.
And then as of September the 26th, 2016, how much cash from Mrs. McIver's account was actually transferred into Mr. McIver's account?
Almost $70,000. And you'll notice that number is almost 25% of the total sources in the first 9 months of 2016.
And this graph illustrates that the sources of cash from Mr. McIver from the last year he was an equity partner until the date of Mrs. McIver's death, it seems to decrease every single year.
That's correct.
That's Dean Driscoll, prosecution's expert witness on financial aspects of this, and basically showing Linda this graph, which I think demonstrable, evidence like this is really powerful, more than just the words, of a precipitous decline of his equity interest as a partner in a law firm, showing that he was losing significant amounts of assets. But you said on break. But in the end analysis, the jury didn't convict him of malice murder or purposeful intentional murder, but aggravated assault. And during the aggravated assault, she died, therefore it's felony murder. So does that mean they didn't buy the financial motive, or they only bought it to the extent that he wanted to hurt her, but not really kill her?
Well, that's a real problem. But obviously, they didn't buy it hook, line, and sinker because they couldn't find the intent there that he wanted to kill her, even though the motive is the intent. That's the best thing you can have, right? So what they did find is somewhere along the line, for whatever reason, he wanted to hurt her, or maybe it was a recklessness that elevated itself to an intention, kind of a knowing, he knowingly shot, and therefore he hurt her. But to me, the whole thing doesn't make any sense. Either the motive flies or it doesn't fly.
Yeah, Gene, what do you think about that? I mean, usually an aggravated assault charge basically throughout the country says that you either acted purposefully or knowingly, or substantial recklessness that causes significant or serious bodily injury to another person. But the jury did not come back with that he was attempting to kill her. So did they buy this motive evidence, or didn't they?
Compromise verdict. That's all I'm going to tell you. They probably discussed it among themselves privately that the malice murder was a very severe charge. And they do think that he planned and he premeditated, but they found him guilty on 4 counts. I think it was a total compromised verdict. I really do.
Yeah, and Gene, let's not forget that, some of the quotes from the jurors, that it took a lot of compromise. They were flip-flopping all over the place. Another juror became convinced, a lot of them became convinced on the weapon evidence and the recreation of that. There you see Tex McIver. Guys, we got to go to a break, but we'll be back with more of this fascinating Law and Crime Rewind. Don't go anywhere. This is the Law and Crime Rewind from the best cases, the best of the best of 2018. And Tex McIver certainly was one of those cases. Did this gun just accidentally go off? Or was it, as the prosecution suggested, a purposeful act to kill his wife? This prominent lawyer, now defendant, sitting there, ultimately convicted, as we believe, in a kind of wobbly verdict there. But listen, this question about whether a gun can just go off or not became a centerpiece of the defense's case. So let's listen to what they said about that in their opening statement.
Detective Smith, okay, did you guys take turns driving down there? Or did some of you drive more than others? Mr. McIver said, I think I drove. Detective Smith said, okay, you're like me. I like to drive when I go. Tex says, I like to be in control. That's the context of that statement. He's just talking about when they drove down to the ranch, that was why he was driving. It's not some nefarious statement he made in connection with explaining what happened on September 25th. This is the gun that went off and shot Diane McIver. As the judge explained, it's made safe, so you don't have to worry about it going off now. I can't demonstrate for you what the trigger pull is because of the lock that's through the gun. But what you'll hear about this gun is it kind of has what I would call two modes: single action mode, double action mode. Some of you who are familiar with firearms may know exactly what I'm talking about, but if you don't, there are kind of two ways you can fire this gun. This is the hammer here. I believe that this is called a shrouded hammer. It's not what I was picturing. When I thought of the hammer of the gun, I thought of something maybe kind of like a sort of an old-timey Western movie, where the hammer's sticking up and it's got a little thumb thing that you click back. This is the hammer of the gun right here. You can see it in the back there. And as I said, it's shrouded, so it's kind of hard to see from the side when you're looking at the gun because it doesn't stick up very far. And again, I want to be clear that the evidence will not show that the gun went off magically or by itself. It was in Tex's lap, in his hand, when it was discharged. And when we say accidental, what we mean is that the shooting wasn't intentional. And I think there are kind of 5 key takeaways you'll see from the forensic evidence that will show to you that this was not intentional. First, as I said, the gun was resting on Tex's lap when it was discharged. Second, it was fired from a sideways position. That's what I was demonstrating for you before, that when Tex was kind of, laid back in the car, sort of slumped down, the gun is in his lap in this sideways position. It's not pointed upright. It's not like this. It's not back by his hip. It is in his lap when it is fired. The gun never comes out of the plastic bag. That is one thing that we can say definitively from the forensic evidence. They can tell that it was fired from within the plastic bag.
Well, there's a lot to digest there. This is the defense opening statement about whether and how the gun went off. They talked about in double action, it's 12 pounds of pressure versus 2 pounds if the weapon had been actually cocked. It was resting on his lap, fired sideways, and was fired while it was on his lap. Linda, I know you got a lot to talk about, but something that just struck me hearing that opening statement again is, was there any evidence that you recall about whether there were any powder burns or powder marks on his lap that may have been consistent with the firing of a weapon, where if it were actually laying on the lap, as the defense lawyer suggests?
No, I don't remember any of that testimony. I think they kind of all agreed on the trajectory because the trajectory was done by the police, right? Mm-hmm. And so she's using the police evidence, which if you're a defense attorney, that's the best to do. But to easily explain what 12 versus 2 pounds is, think about buying flour at the grocery store. It comes in things, right? You can have a 2-pound flour, 5-pound flour, 10-pound. That means you have to hang that bag of flour, for instance, from the trigger, and that's the pull that you would get. It's that much weight. That's the easiest way to think about it.
You know, we were talking before, and one of our producers, Kamana, had asked, like, really, none of this makes sense, Gene Rossi, about what does that mean, 12 versus 2 pounds. I get exactly what she's saying. As a prosecutor, we got to kind of really clarify what these things mean. But the defense lawyer referred to the 2 pounds of pressure as a hair trigger. I have actually witnessed in court myself somebody saying that it would take a lot to be able to fire the weapon, holding the weapon in the court, not loaded, and they pull the trigger. Have you ever, and obviously belied their opinion. These guns can be fired if your finger's on the trigger and you hit a bump on a road, which is what the defense is arguing here.
The opening, which was like a closing, was very good, and she tweaked the government. She said if it's a single action mode, it's hair trigger. The prosecutor gave the impression that this was fired with a double action mode, which requires 12 pounds. That kind of tweaked the prosecution. They were a little bit misleading. The second thing I like about her opening was she gave them 5 key takeaways that you should think about during the trial. Mm-hmm. And I love when either a government attorney or the defense gives the jury a list of things. When Linda goes to Harvard Law School and gives her advice, give the jury a list of things to grab onto.
Right, and we talk about this often, Gene. A point very well taken. The defense had an opportunity to present its case. You don't have to present a case. You don't even have to do an opening, but she did a very effective job at forming, or at least combating, the prosecution's case to give the jury something to think about right from, as we like to say in Jersey, Linda, the get-go. But the prosecution was not about to let this go unanswered. They had Michael Knox, a crime scene expert, who gave testimony in the case. Let's take a look.
This is State's Exhibit 285A. Again, can you take a look at this photograph, and if you could tell the jurors the position of the hands in this photograph, wherein the fingers are in a slightly downward position. Can you tell the jurors, is that hand position consistent or inconsistent with the analysis that you did in the vehicle with respect to trajectory?
It would be inconsistent.
Okay, so there's the basics of that expert's testimony. It's inconsistent with what the defendant is saying, that this was an accidentally fired while it was in his lap. But the defense is going to have an expert here, Ross Gardner, who's going to be providing some information, hopefully to support what the defense is saying in the case. Let's take a look.
And you can see this situation where I've pushed my arm back. I've got some space here. So I can gain 2 or 3 inches, but I'm still problematic with the forearm. Because if I'm in here, I don't know how I'm going to get the gun down over here on the hip.
I mean, let's assume somebody actually, like that, forced their arm back into that space. Would the 3D demonstrate?
We're rewinding on the Tex McIver case, and that is a crime scene analyst, Ross Gardner, for the defense. He's a guy who teaches the actual criminologists that do this work and is an expert in 3D imagery and reconstruction. Linda, experts can be very, very tricky because it can be very speculative, and you've got 2 experts here that are giving 2 completely different opinions. Somebody's kind of got to be right and somebody's kind of got to be wrong.
Well, the problem is that sometimes an expert say, as the state's expert, consistent with or not consistent with, and that's really not a scientific finding. You have to make scientific findings. You know what is a scientific finding? When the gun goes off in the courtroom, like I had in Jason Williams, in our Jason Williams case out in North Jersey, where the prosecution expert is coming off the stand, being cross-examined, trying to show the jury how the gun can't go off, and guess what? It went off.
Yeah, you know, to that point, Gene, sometimes these expert conclusions, I find in the 30 years I've been practicing, are becoming wider and wider and wider in terms of what judges are allowing. And there's been a big debate out there that some of this stuff isn't scientific at all. It's just merely speculative. And one team gets one expert, another team gets another expert, says something the opposite. Your thoughts?
Yes, I think experts can explode on you. In December of 1998, I was a federal prosecutor. I called an expert in a marijuana drug conspiracy case. He turned out to be the defense's best witness. He was cross-examined. He left that witness box like a pretzel. And they acquitted my defendant. And I've always felt that if you're going to call an expert, they have to, as Linda said, they got to give findings. They can't say consistent with this, that, and the other thing, because you can twist them like a pretzel.
Yeah, I have personally, I won't pat myself on the back, taken many experts and converted them to my own use because they either weren't prepared or there was so much information or data that they'd given in other cases that I had in my possession that contradicted their opinion, that at a minimum made the other side look horrible. But, you know, to your guy's point, Trials are not exact sciences. I say that in every opening statement or somewhere down the line. There's no retakes. It's not like TV. It's not done in half an hour. But you gotta worry when you've got your crime scene expert that's on the stand saying that guns don't just accidentally discharge. And then, in summation, the defense is able to get a clip, Linda and Gene, from the great Law&Crime Network. We actually got incorporated into a trial where the defense used a clip from this very case showing something that had to give the prosecutor an anxiety attack. Let's take a look.
Action, so the hammer comes, it's primed, it's ready to be fired. The only way that the gun will fire is if the trigger is pulled and then held to the rear long enough for the hammer to fall. So if you were to pull the trigger, but then release the trigger, and I'll put my finger here so that I could feel it if it went through, it doesn't touch. Because you notice the trigger
Oopsie. You know, I would have been jumping up in my chair saying, I want the record to reflect that as this witness, I'd make the standing objection. Let the judge put me in contempt. As this expert was trying to say what can't be done, he just did.
Right. That's exactly what we did to Jason Williams. Say objection, and put it on the record. You have to put it on the record. So something went wrong here that the jury didn't think this was important, right? This gun could accidentally go off when you're holding it with the poundage from above. You know, that's why I'm confused about this verdict.
Well, I mean, this very well, Gene Rossi, could be the reason why the jury didn't come back with an intentional, premeditated and or planned or malice murder, as they call it, because this is exactly what the defense said. Look, that's the Law&Crime clip. That's the clip from our very own network that got incorporated. Let's make sure we're clear about this, Gene Rossi. They took our clip from the Law&Crime Network and used it in closing, the defense did, to show it is a hair trigger.
That is a beautiful thing, number one. But I know why they acquitted on count one, malice murder. In the opening, the defense attorney said that the defendant was arrested, but he wasn't arrested for murder, only for involuntary manslaughter. So they planted the seed in the jury's mind that even the prosecutors didn't think they had enough for count one, malice murder.
That is an excellent point, and as the case moved on, it kind of got elevated and elevated. Guys, we got to go to a break. I love having these guys on, and I think I'm going to be laughing about that for the rest of the day. They used a Law&Crime Network clip, the defense in summation, to show that it was a hair trigger.
The state has just let him. I'll cut him off. Go ahead. He needs to be cut off. The state introduced numerous witnesses that this witness was in the bedroom the night after Tex McIver died. Went to the ranch, wore the boots. Okay. And now I can't ask any questions about the effect that those kinds of allegations have had on her and her family.
Correct. You cannot. Not for this trial.
I don't want you to mince words with me. I don't want this to be like a Bill Clinton type of question and answer. Did you ever at any time, and I'm talking about any time before Tex McIver's death or after her death, either before September 2016 or after September 2016, engage in any sexual conduct, however you want to define it, with Tex McIver?
Never.
Does that include in his conduct?
Yes.
Objection, Judge. She said never. We don't have to go down the long list.
Oh, come on. Mr.
I'll give you three.
Yeah, I've got more to go.
Okay.
Okay, that's the massage person, Annie Anderson. There's a lot going on there with this witness as well. Essentially, the defense has her on to say that this allegation that he was having Tex McIver a sexual affair with her is absolutely not true. I want to go to a practice point here, though, Linda. Wow, the speaking objections. Now, I get a little bit of a speaking objection, but even though the judge ruled in favor of the prosecution, the defense was able to get that argument out. And call me naive when I don't believe the jury can just excise everything when it doesn't. Yeah, they heard it. They knew what he was trying to say.
Right. You know, and quite frankly, I mean, they didn't even need him to say that. Look, if this woman is a licensed massage therapist for 20 years, the prosecution has no evidence she's having the affair, because once they say it's motive, right, it's supposed to be money, and now it's this. I mean, it's terrible to bring that up. This would ruin this woman's life in the community. So I don't really care whether there was an objection that was a speaking objection. I think that was outrageous.
Gene, do you think this, I mean, I'm going to go to you because you're a guy out there, Virginia, D.C. area. You guys, horse farms and lots of money and things that I just don't get and understand. I don't roll in those circles like you do. Having your own massage person at your ranch and all this stuff. Was this witness effective for the defense at least to say the prosecution's thrown everything up against the wall and now we have to disprove it, and we are disproving it? Don't believe them.
I thought she was very effective, because the worst thing a prosecutor can do is make an allegation, either express or implied, that is simply untrue. Mm-hmm. And what Annie Anderson is doing is, and her demeanor, this is why I love trials, her demeanor tells me that she is offended and outraged that I am a massage therapist is being accused of having a physical relationship with my client. And you could just see in her answers that that is just an unfounded allegation. And I got to tell you something, if they did make that express or implied allegation, shame on them.
Right. As a prosecutor, everything you say has to be provable, and you can't be putting yourself in a position where you're distrusted in the least, in my opinion, even more so than a defense lawyer. But that wasn't all of her testimony. No, because a defense lawyer has a different burden, a different responsibility in the courtroom. But this didn't end with her testimony, because the defense also wanted to show that he was sleepy in the back of that car, Linda, that he had this weapon that had accidentally discharged. So we actually got into the massage slash sleep patterns of Tex McIver in this crazy case. Let's take a look.
So not in the conduct. I'll do it later. When Mr. McIver received the massage, is that the right verb? Received, had a massage, received a massage. Did he ever fall asleep on the massage table?
Almost every time.
When he was asleep, did you notice anything about any unusual behavior?
Yes.
Tell the jury about it.
He would have conversations in his sleep, and then depending on what he was saying, he would act things out, or he might just be quiet and all of a sudden flare an arm or kind of a punch or something like that, and I would have to get out of the way if I was close to his body in any way.
All right, massage therapist Annie Anderson gives us now what would be part of the defense. So the witness was used in two ways. One, to attack the prosecution for a wild speculative claim, if made, that they were having a sexual affair. And then Gene, the second piece to that is that he does fall asleep, very easily. Now, I haven't slept in about 5 years, so I envy this guy. But do you think that this was something that was effective, that goes to he may have just fallen asleep and jerked his arm and accidentally pulled the trigger?
Yes, I do think it was effective. And that's why the jury deliberated over 5 days. I thought it was very effective.
All right, yes. Listen, hey, Gene Rossi, Linda, Kenny Bodden, you guys are the best. It's so great to have you as the first two guests of 2019. We're going to go to a break. We'll be right back. Don't go anywhere. All right, we've exhaustively done a rewind on one of the more fascinating cases that we covered here on the Law&Crime Network in 2018. Tex McIver, prominent Georgia attorney on trial for murdering his wife. This was an amazingly lawyered case. Kudos to the prosecution. Kudos to the defense lawyers. My guests, Linda Kenny Bodden and Gene Rossi, love to see great lawyering in that courtroom. But like everything else, at a certain point in time as lawyers, we got to let it go and give it to the jury and await their determination. Let's not forget, he's charged with malice murder, aggravated assault, felony murder, weapons offenses. Let's take a look at the jury's verdict.
Juror 20, I would like you please to publish the verdict, which means read the verdict into the record.
On count 1, murder, we find the defendant not guilty. On count 2, felony murder, we find the defendant guilty of felony murder. On count 3, aggravated assault, we find the defendant guilty. On count 4, possession of a firearm during the commission of a felony, we find the defendant guilty. On count 5, influencing a witness, we find the defendant guilty.
Thank you, Juror 20. You can take a seat. Deputy Murphy, if you would please read the verdict form to Mr. Rucker and then to Mr. Harvey.
Wow, and there you have it. Linda, we got a short period of time to discuss this. This was the contradiction here. Not guilty on malice murder, but guilty of felony murder for a man his age. That's it. Lights out. You're going to jail for the rest of your life.
Right, and he looks like he's sickly. He doesn't look like he's a real strong type of person. He may not even make it through the appeals. I think this case is going to come back on the appeals on the issue of felony murder. Sometime someone's going to address that.
Yeah, I mean, Gene, as we had talked about before, and our audience should know, a great weight of legal authority here, especially after some of those juror comments, are very concerned, and there could be an appellate issue with regard to an inconsistent. Could be, but look at his face there, Gene. He's almost emotionless. What are your thoughts?
I think he's stunned. After he heard not guilty on count 1, he thought it was going to run the table. And I got to say, he does look sickly. I don't think he could last more than 2 or 3 years in prison.
Yeah, and, you know, I think that sometimes, you know, when jurors do that compromising verdict, like you said, I'll just give you like 10 seconds or less for each of you. I think sometimes they're shocked that when they do convict them of the compromise thing, that they get the amount of jail time, and they kind of have buyer's remorse. Real quick,
Yes,
Linda.
and I thought I saw a juror comment that said that they were shocked that he's going to go to jail for as long as he is on the felony murder.
Yeah, that's why compromise verdicts are difficult, Gene. That doesn't necessarily approximate justice.
Exactly. There was a famous federal trial in West Virginia, the coal mine owner, and they came back with a guilty on a misdemeanor. And then the jury, one of the jurors said, "Oh my God, I would have voted guilty on the major count if I knew he was only going to have a misdemeanor."
Right. Well, listen, Gene, Rossi, Linda, I know you got to go, and you're going to be coming back, and you're going to be hosting in a little while. We're going to have to go to break, but we're not going to end with the rewind here, because we have Daniel Villegas, who is coming up with one of the other trials that we covered. We're going to be doing that next. I'll be with Gene Rossi. We're going to go to break. Stay tuned. We'll be right back.